The matter before the court this morning is the case entitled State of Vermont versus Randy Bluto, case number 23AP133. Representing the appellant, Randy Bluto, is attorney Mila King-Musa. Representing the appellee, State of Vermont, is attorney Diane Wheeler.
Right. Attorney for the appellant, can you please identify yourself and your client and proceed?
Thank you, Your Honor. Good morning. I am Mila King-Musa with the Vermont Defender General, and I represent appellant Randy Bluto. This is an appeal of a restitution order for $1,699. Before I address the merits of the case, as the court knows, the state has not responded and certainly not opposed any of the arguments here. I do not think it is a stretch to say that the state has effectively conceded. With my short amount of time, I would like to address the sufficiency argument, which luckily is very straightforward in this case. Patterson, the complainant, came into the possession of the light bar at issue because it came with a 1989 truck that he purchased for $4,000. He didn't know how much the light bar cost. He didn't even know how old it was. The only evidence at the hearing of the value comes from Patterson, who found a light bar online that looked similar and printed out a picture.
So, Ms. King-Musa, is the complaint that the 1,026 or whatever the actual amount was, that's not reflective of the bar's fair market value at the time of the loss?
Correct, Your Honor. It's that the state did not prove that that $1,699 was the fair market value of that particular light bar. After all, Patterson, found this picture, printed it out. He didn't use any serial numbers to confirm that this printout was an identical replica or was similar enough to the light bar on the truck at his time. He didn't, like I said, he didn't use any serial numbers. He didn't have an employee or a mechanic confirm it. And what makes this situation even more tenuous is that the actual damaged light bar was in the trunk of his car the day of the court hearing. They didn't admit it. The state's attorney and the complainant had taken photos of the light bar as well, I believe, and those are not admitted at all. And these could have confirmed the likeness and the similarity of the photos and the actual light bar, but they simply were not admitted. And Patterson himself thought the light bar was worth much less on the night of the incident.
It's the value at the time of the loss that matters the most, correct?
Exactly, Your Honor. Yes.
And this is this is, I think, likened to a civil judgment, or is actually a civil judgment. So the burden of proof would be by preponderance.
Yes, Your
Honor. Damages.
It is part of the criminal punishment and criminal sentencing, but the standard is preponderance of the evidence. Correct. And it is our argument that a simple photo printout online just does not rise to a preponderance of the evidence, particularly when taken into context with what the defense submitted, which was, there were two conversations with people familiar with the light bar at issue who were not interested, who had no interest in the value of the light bar itself, who were familiar with cars, who worked on cars, and said that, the fair market value of that light bar when it was damaged was max $300. And so, it is simply our argument that the state did not prove, even to a preponderance, which we know is lower standard, that the fair market value was $1,699. If the state has no further questions about the sufficiency argument, I would love to touch very briefly on the Apprendi argument here. Your Honor, I'm sorry.
Sure. I'm Justice Carroll's in charge, so.
So Apprendi holds that a jury must find any fact other than a prior conviction necessary to support a criminal sentence. Southern Union Company holds that Apprendi applies to all punishment, not just imprisonment. Vermont
isn't a restitution order a separate order from the sentencing? There's a separate judgment order, isn't there?
Your Honor, it is a separate order. However, even in the restitution statute itself, in 13 VSA 7043P, it says that an obligation to pay restitution is part of a criminal sentence. This has been reflected in Vermont case law as well. So there's both case law and just in the statutory definition of restitution that it is part of a criminal sentence.
And was that issue raised below?
No, it was not, Your Honor. It's our argument that this was plain error. It's clearly contrary to the Sixth Amendment, the Due Process Clause, clear United States Supreme Court case law, and it calls into question the integrity of the proceedings. So we do believe that this was plain error. And with that, my time is up, and I thank you, the court, for listening today.
All right, appellee, counsel for appellee, please introduce yourself and your client and proceed.
Yes, Your Honor. First, state would ask for permission to speak, given that it did not file an appeal.
Right. Go ahead.
Thank you, Your Honor. My name is Diane Wheeler. I'm a deputy state's attorney in St. Albans, Vermont, Franklin County, and I represent the state in this matter of State v. Randy Bluto. Your Honors, first I want to apologize to the court. This was an issue or a case that fell through the cracks given the tumultuous issues that have presented in my office in the last 18 months and the changeover. I'm the last standing deputy state's attorney in Franklin County, and thus I am here with you today. The worst part is somebody actually wrote the brief, it just did not get filed. However, the state would like to point out that this is the standard of review for this under State v. Gorton and State v. Blake is abuse of discretion. In this particular case, Judge Maley heard the evidence and in fact put on the record that he did not find the defense evidence credible, and thus based his decision on what he found to be the credible evidence of Mr. Patterson.
But Ms. Wheeler, doesn't the court have to make a determination as using evidence that's introduced into the hearing as to what the appropriate fair market value of the damaged goods are at the time that they were damaged? Isn't that that's part of this whole system? And so the evidence that that Judge Maley had at the time, did it reach to a level of sufficient evidence for the court to make a fair market value determination?
Yes, Your Honor, it did. It was based on the testimony of the witness who owned it, who had bought it, who had purchased it, and had researched to the best of his ability the fair market value at the time. The court did also note that the market value was the proper measure for restitution, which is a civil order, a civil judgment order, and the state argues is not Apprendi is not applicable to that. Also, Your Honors, the state would note that because under State v. Van Dusen and the like, that the proper measure, there are times when we cannot properly specifically measure something, such as I believe the court notes that there's no such thing as a blue book for a toaster. And so that given toasters are microwaves. And again, that is in State v. Tatro, which is a memorandum. Also, State v. Driscoll has recognized that some restitution awards necessarily involve an approximation. So given the case law on that issue, Your Honor, the state believes that Judge Maley appropriately found that $1,699 was the appropriate figure. And he did not abuse his discretion based on the evidence he heard that day at the restitution hearing. The state also would note, again, there is no right to a jury trial for restitution, and it is a sentencing condition under State v. Morse. And although it is termed a sentencing condition, it is often and has been a condition of probation to work with the restitution order, the restitution unit. However, the order itself is a civil order that follows the defendant even after he is no longer in custody under sentence with the Department of Corrections.
And Ms. Wheeler, what about the disproportionality argument saying that the amount was 3 times what the maximum fine would be for the offense.
Well, Your Honor, when I'm looking at that, the state would note that that would bar a great number of plea agreements in the state of Vermont. That the restitution is not limited by the offense element. And specifically the—
Ms. Wheeler, you were looking down. I wanted to make sure you saw. You have 1 minute remaining.
Yes, thank you, Your Honor. That specifically in the court has ruled that restitution is not limited by the element of the offense. This disclosure was made, the state proved the damages, and the restitution order is valid and should be. Thank you. I thought that was the bell for the end of the argument.
No, it's my actual telephone that was going off, and my home phone. I still have a landline.
I'm sorry.
That was going off, so I apologize. I didn't mean to throw anyone off on that.
Ms. Wheeler, you're free to finish if you'd like to.
Thank you, Your Honor. That this court has previously heard argument on whether restitution may exceed the value, and the court has indicated that that is not, it just needs to be related to the conduct for which the defendant is charged and is convicted, not to the dollar amount. So with that, Your Honor, Your Honors, again, the Franklin County State's Attorney's Office apologizes for all this lack of brief, but appreciates the opportunity to be heard.
Okay, thank you.
I apologize for the phone call and that it disrupted your, but maybe we should use the bell. I mean, that maybe not a bad idea. But.
Does appellant have any time remaining, bailiff?
Appellant has no time remaining.
All right, so thank you very much for your arguments, and we'll get the order out as soon as possible, and the bailiff